When I first came on the court, I had to recuse myself because of my panel and cases I ruled on, I couldn't be on. And at the time, there are certain cases that I just cannot be on, but at the time my daughter was a partner of Jenner and Block, so I didn't do any Jenner and Block cases. But since she has been gone for a while now, so I do Jenner and Block cases. So things like that, I recuse myself for. And if I'm very close to somebody, but not just because I know another lawyer, but if I know a litigant, then I will not.
Again, to generalize from one lawyer's experience, it's not the kind of court where all 7 justices usually jump in a kind of chorus, peppering questions. My memory is it's often a single justice who sort of takes the lead. Is that your experience, or is that just a...
I think there are more aggressive justices. And I don't say it's a lead, but some of them, it might be just interest, too. It isn't necessarily the judge who is the author. We all have read exactly the same amount. We've read the briefs. If we get a chance, we might read the seminal cases in each brief. But with all those briefs in that short a time, we really don't. The research division of our Supreme Court does a synopsis piece for us. So if we read when we read the briefs before, we have that piece before us. But basically, some people are more aggressive in their requests. I mean, on the United States Supreme Court, Clarence Thomas, I don't ever think asked a question. That doesn't mean he doesn't have opinions on things, or he's not, he's thinking about things. But I think it's just who really is in a specialty area. Some people are better at contracts, and others are better at criminal law, and others know juvenile court matters better than others, and so you might be a little more aggressive if you're very familiar with that area, or you've had a case in which you've written and you're familiar with that at that time. It's in recent time that you're familiar with it. You're going to ask more questions, and it all depends on how you feel that day, quite frankly, and what the oral argument's about. If the attorney is speaking to what your questions are, you don't have any.
Right.
But if the attorney isn't getting to that, or just rehashing the facts or rehashing what's in the brief, then you might have more questions to try to pull it out, but sometimes it's an act of futility.
Now, the only court of review you have, and only rarely, in a sense, is the U.S. Supreme Court.
Yeah.
So how often do they take cases that are reviewed from your court?
I don't think they've taken any since I've been there.
Really? Yeah.
Since I've been there, and it'll be 6 years. So no, not since I've been there. I know they have, and cases that basically I think are criminal matters, civil rights, criminal matters that I recall. I mean, that would liberty interests at stake, things like that would really.
So what's it like? I mean, this is what I'm leading up to. What's it like knowing that, for all intents and purposes, you are the final decision makers on?
I know.
Just on a personal level, what's it like feeling that responsibility?
It's scary, and it's pretty heart-wrenching, and sometimes I don't always agree, but this is what the law is, and this is what the statute says, or this is what my colleagues say, and I feel like it's an act of futility. I just feel terrible. It's awful. But I can't do anything about it, I mean.
Someone has to decide.
Somebody has to decide. And I have written a number of dissents. In fact, I have to tell a cute story about the room that I moved into when I went on the Illinois Supreme Court. It was called the Cartwright Room. And Justice Cartwright moved into that room February 4th, 1908. He had been on the Illinois Supreme Court since the late 1890s, James Cartwright. But when the first justices moved in to their rooms, the room was named after them. But by the time I got there, the plaque on the wall listed most of the justices who slept in that bedroom since James Cartwright. And one of them was Justice Seymour Simon, who was a dear, dear friend of mine and my family's. He was an alderman with my father-in-law and with my husband. Okay, and his son John is actually a good friend of my husband and mine. He was my campaign director, chairman, when I ran for the Supreme Court and the Appellate Court. So when I moved into his room and I saw his name on that plaque, Justice Simon, I took a picture of the plaque, and Justice Simon was ailing and he was in the Rehab Institute in Chicago at the time, and I went to see him and I said, "Justice Simon, I'm sleeping in your bedroom." And he says, "Say it louder so the nurses can hear." But
tell a story. Go ahead.
So, but Justice Simon was known for his dissents. When I was on the appellate court, I wrote that one dissent that I spoke to you about that my colleagues helped me with. That was the only time I actually wrote a dissent. I had written some concurring opinions. But now, since I've been on the Illinois Supreme Court, I have a couple dissents every term. I don't know what got into me, and I keep on saying it's the spirit of Justice Simon is coming down at night and telling me, "You've got to speak louder on this issue," and that it's amazing.
Well, and we all know from the development of American jurisprudence, it's those dissents, especially on Supreme Courts, that they may be a little ahead of their times, but they often lead the way toward a change of the law. It might take decades, but it can happen.
Judge Daniel Ward, who was a state's attorney in Chicago many years ago, actually my husband Ed was a policeman who was his driver in going to law school, and then Justice Ward became the Chief Justice on the Illinois Supreme Court. He wrote a dissent in a case called Mackey, which actually was the dissent that eventually became the law on contribution.